Hey guys, it's Mo from Mo in the Deep End, and we've got some interesting updates from the Karen Reed case. I got this from Reindeer. She sent this to me, and it turns out our boy Turtle Boy, the face that's turned up to 11, all caps, bold, underline, has been arrested. I don't know if it's for contempt of court or facial movements. We will see. But looks like Turtle Boy, our favorite independent journalist or blogger, as he's called in the local news, has been arrested on multiple counts. So let's see what he's doing here. Stoughton, Massachusetts, Aidan Timothy Kearney, who is also known for his controversial and confrontational quote Turtle Boy blog, was arrested on multiple counts and is in custody. Slaughton County District Court records show he faces at least one count of conspiracy and 8 counts of intimidation of a witness, juror, police, or court official. The court clerk said Kearney is currently in the custody of Massachusetts State Police. Kearney's prosecution is being handled by Special Prosecutor Kenneth Mello. Additional details about the charges were not immediately available. Paperwork typically becomes available after arraignment. Kearney has blogged prolifically in the recent months about the murder case against Karen Reed, who is accused of hitting John O'Keefe, a Boston police officer, with her vehicle outside of a home in Canton after a night of drinking on January 29th, 2022. Reed and her defense team have attracted widespread attention with allegations of a cover-up. As of Wednesday morning, all 5 of the top stories on the blog are related to the Reed case. Uh, Here's my man with the face at 11. Uh, thro Through many of Reed's pretrial hearings, Kearney sat in the courtroom a few rows behind the defense table. He was often visible in the background while attorneys spoke in the court or at the courtroom podium. In streaming coverage of high-profile hearings, Kearney wore a sweatshirt printed with the slogan "Free Karen Reed" as he was escorted into the courthouse on Wednesday. You mad lad. Norfolk District Attorney Michael Morrissey, whose office is prosecuting Reed, issued an unusual video statement in August condemning the dissemination of false narratives and harassment of witnesses involving the case. Quote, "We try people in the court and not on the internet for a reason," Morrissey said in a statement. "The internet has no rules of evidence. The internet has no punishment for perjury, and the internet does not know all the facts." The judge overseeing Reed's case denied the request from the prosecution to rein in statements made by her defense team. As a result of a hearing last month, which Kearney attended, Reed is scheduled to go on trial March 12th, 2024. So there you go. And let's see, there is a video of his uh, hearing. So let's see if we can watch that. Let me stop that screen, present, share screen, volume, full screen, share. Okay, so I have These offenses taking place on various dates. One count of picketing court, judge, or juror. That offense taking place on June 6, 2023 in the town of Canton. Docket 23 CR 1159 being charged with one count of intimidation of a witness, juror, police, court officials. Those offenses taking place on various dates. One count of picketing a court, judge, or juror. That offense taking place on June 6, 2023 in the town of Canton.
Thank you. Good afternoon, sir. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violated release condition during the pendency of any one of these cases, one or more of these cases, you could be held on any one or more in the House of Correction for up to 90 days without bail. Counsel, does the gentleman qualify? Yes, private counsel. Okay. Mr. Reynolds, will you stand in for today?
Yes.
And for the Commonwealth?
Good morning, Your Honor. Attorney Kenneth Mello, Special Prosecutor for the Commonwealth. With me is Attorney Robert Novak, also Special Prosecutor of the office.
All right, good afternoon, both of you. Good afternoon, Mr. Reynolds. Mr. Mello, do you have any requests for the court?
I do, Your Honor. I have a number of requests for conditions of release. Where Commonwealth is requesting cash bail in the amount of $1,000, GPS monitoring, stay away from all witnesses 100 yards, and that would be with the exception of court appearances that the defendant is required to attend if other witnesses are present. We're asking for a 100-yard stay away from the witnesses' homes, businesses, places of employment, and schools.
So I guess I'll have to ask David, but does that mean that he won't be able to go to hearings or he'll have to watch them on video? Because I'll miss his faces.
We're asking for no contact with witnesses by phone, text, email, or otherwise, either directly or indirectly. We're asking that the defendant, through his blogs and internet use, not encourage, or court order him to not encourage any of his blog followers to call or visit or otherwise intimidate or harass witnesses. As Your Honor may be aware, this defendant has a blog with a rather large following.
Are we still using the word blog? I mean, I know I'm out of the loop and I'm not really good with tech stuff, but are we still using the word blog? I just need to know because I don't want to be a boomer.
And that will get to the root of the case itself, but it appears that in the past he has he's encouraged his followers to take various actions with respect to witnesses in this matter. We're asking that there be no harassment of witnesses or their families, no intimidation of witnesses or their family members. We're asking that he not on his blogs or otherwise encourage his blog followers to photograph witnesses, their families, their homes, etc. As Your Honor will hear from the evidence presented by the Commonwealth's argument, the defendant has shown up at sports games attended or that were being engaged in by children of witnesses, and has made scenes there using loudspeakers, etc. We're asking that he be precluded or prohibited from attending those sports games, school or otherwise, to harass witnesses. That there be no mentioning by names or other forms of identification of the witnesses on his blogs, Twitter.
Wait, so you basically just want to take away his livelihood. I mean, look, I get the point of him not showing up at games and stuff, and I'm going to move this to 1.25 because I don't have time to sit through 47 minutes. But
when I say witnesses, I'm also talking about the victims in this case, Your Honor. The victims in this case all being witnesses in another matter that the Commonwealth will address.
but for serial,
they preclude the defendant from talking about other cases, but not with respect to discussing the witnesses and their family members, etc. We're asking that he have a stay-away order from D&E Pizza, and that he be precluded from encouraging his blog followers from harassing and intimidating that business, that he not contact witnesses, family members, schools, sports teams, coaches, etc. He has done that in the past, Your Honor. That he not photograph or video witnesses at home or work, and that also goes to taping, Judge. And he not contact the place of work of the witnesses or victims. And I have a large number of facts I would like to make the court aware of. I apologize for the time it's going to take. There are 9 complaints before Your Honor. Some of these facts apply to all. If I could just read that section to the court once, or recite those facts, and then deal with them individually. Thank you, Judge. Your Honor, on the morning of January 20th, 2022, a gentleman by the name of John O'Keefe was found unresponsive on the front lawn of 34 Fairview Drive in Canton, Massachusetts.
Look at all the people that are here. I mean, I don't understand, and this kind of parallels with the Delphi case and the state moving kind of in the night quickly to try to seal all of the forthcoming, basically trying to put everything, all court documents under seal again to make them not public anymore, um, petitioning to not have cameras in the court. I mean, again, I don't know if the state is unaware of optics or they just don't care, but whether or not he did these things, optically, this looks terrible. This looks terrible. This looks like the long arm of Boston PD, uh, you know, slamming down hard on someone trying to uncover the truth. Now, again, if he did shenanigans, if he made people feel unsafe, bad on Turtle Boy. If he was a hooligan, if all of these things are true, let's say the state is completely right in bringing charges. Optically, it still looks horrendous.
Transported to Good Samaritan Hospital, where he was pronounced deceased. The Office of the Chief Medical Examiner determined the cause of death to be blunt force to the head and hypothermia. Evidence was presented to the Norfolk County Grand Jury that indicated on the night of January 28, 2022, Reed and O'Keefe were at 2 Canton restaurants, C.F. McCarthy's and the Waterfall, where they met friends. And this is Karen Reed. After the Waterfall closed at shortly after midnight, Karen Reed and Mr. O'Keefe were invited to 34 Fairview Drive, Road in Canton. Witnesses stated Reed and O'Keefe did not enter 34 Fairview Road. The Norfolk Grand Jury indicted Karen Reed on second-degree murder, motor vehicle manslaughter while operating under the influence of alcohol, and leaving the scene of a motor vehicle crash causing death. The indictment alleges that Karen Reed struck O'Keefe with a motor vehicle and left the scene, and the case is currently pending in Norfolk Superior Court as docket number 2282 CR 117. The lead investigator.
Just for the record, there are many people attending this hearing via Zoom. We're doing the best we can to keep them all muted. When you hear some random utteration like you just did, that's from someone who has not yet been.
Thank you, Judge. The lead investigator for the investigation I just described is Trooper Michael Proctor of Massachusetts State Police, assigned to the Norfolk State Police Detective Unit. Trooper Proctor testified before the grand jury and continues to conduct investigative work on the case. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to the investigation, but a family member, as mentioned in Chapter 268, Section 13B of the General Laws. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. These civilian witnesses were present with O'Keefe and Karen Reed in the hours leading up to O'Keefe's death and his discovery on January 29th.
Okay, well, let's.
The witnesses include the following: Matthew McCabe, who was interviewed by investigators. Matthew was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, and observed an SUV believed to be that of Karen Reed's in the front of 34 Fairview Road, and he testified at the grand jury. Jennifer McCabe was interviewed by investigators. Jennifer was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV believed to be Reed's in front of 34 Fairview Road, and was with Reed when O'Keefe was found unresponsive, and testified at the grand jury. Brian Albert, interviewed by investigators. Brian was with O'Keefe and Reed at the Waterfall Restaurant, and the homeowner of 34 Fairview Road, and testified at the grand jury. Julie Albert, the wife of Christopher Albert, was interviewed by investigators. Julie was with O'Keefe and Reed at the Waterfall Restaurant before O'Keefe's death, and she testified at the grand jury. Chris Albert, husband of Julie, was first interviewed by investigators on February 10, 2022. Chris was with O'Keefe and Reed at the Waterfall Restaurant before O'Keefe's death and testified before the grand jury. Colin Albert was interviewed by investigators. He is the son of Chris and Julie Albert. And Juliana Nagel was interviewed by investigators. She was present at 34 Fairview Drive when people were arriving from the Waterfall Restaurant and observed an SUV believed to be that of Karen Reed parked in front of 34 Fairview Drive. In an April 2023 motion filed by Reed's defense attorneys, defendant's motion for order pursuant to Mass Rule of Criminal Procedure 17 directed to Brian Albert, Verizon, and AT&T, alleged police misconduct and a conspiracy among civilian witnesses to frame Reed to the death of O'Keefe. The motion calls Brian Albert a suspect and Jennifer McCabe a conspirator who took calculated steps to purge her phone of this inculpatory evidence. A local blogger, the defendant, Aidan Kearney, had adopted the defense's claims. Kearney runs a series of websites and social media accounts under the name of Turtleboy. The social media accounts include TV.
How dare he take an opposing opinion? Dang it. I mean, look, again, how dare he take an opposing opinion? I mean, the state basically has laid out what they think, and you should not deviate.
TV Daily News, X, formerly Twitter, with 33,800 followers as of last count. Aidan Kearney at Dr. Turtleboy, X, formerly Twitter, with 44,800 followers. Turtleboy, Facebook with 27,000 followers, and Turtleboy Live on YouTube with 41,000 subscribers. He refers to his followers as Turtle Riders. Now, it should be noted that the defendant on many of his sites, his websites or blogs, if you will, has a pay section where he's requesting contributions from the public to support his work.
Oh, holy God, he's asking for money. Does that make him a prostitute? Or how dare he ask for money when he devotes a lot of his time and effort into, going out and asking questions? A Again, look, if he was an unruly hooligan to these people, then he's crossed the line, and that's wrong. But if they're just mad because an opposing viewpoint is getting out there and they've trumped up charges, then this is for damn ridiculous.
If you will, and some indications are that it's been estimated on the internet that he has raised in excess of $5 million doing so. So this is apparently a business of his that he's engaged in.
Not a business, not commerce.
Kenny began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses and members of their families and their friends. Kearney authors and publishes a blog on the website tvdailynews.com. The website has a series of articles entitled Canton Cover-Up. As of September 28, 2023, at least 164 articles have been posted to the website in this category regarding Karen Reed, and there have been additional articles since that date. Kearney posts weekly videos to YouTube where he has discussed Karen Reed and made statements regarding witnesses. Below are a small selection of the verbal statements made by Kearney in these videos that have been published to followers and are publicly available for viewing without being a subscriber or follower and have been archived by investigators. Episode 594, Turtleboy returns to Canton. This is a video posted shortly after Kearney visited homes of witnesses. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. These people think I'm fucking around. You haven't seen the last of me. Get used to it at the 119 mark. Episode 598. Karen Reed defense files motion to recuse. This guy, meaning Chris Albert, had his head on the swivel looking for turtle riders. I got bad news for you, Chris. I got really bad news for you. They are literally everywhere. You guys should just stop going out in public. It's only going to get worse from here. I know where you all were today. You were in Agawam, weren't you? You guys were at some sort of Little League thing in Agawam. Alberts, McCabe's, all you people were there. Just know that there will be no life as normal is over. Life is normal. You had normal for a while there, from January 29th to about April 2023. You guys literally got away with murder. Speaks out of the 8-minute mark. While discussing the video of Chris Albert being confronted outside of a Canton restaurant, we, Kearney and his audience, are getting to them. Chris Albert, meaning Chris Albert and other witnesses. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. These people think I'm fucking around. You haven't seen the last of me. Get used to it at the 119 mark. Episode 599. Turtleboy returns to Canton. This is a video posted shortly after Kearney visited homes of witnesses. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. When you act this way, that's like a green light for me, time to hit the gas. I got pictures of you. You can't leave the fucking country, Turtle Riders. We're gonna find you. They're gonna find you.
Okay, I mean, I understand how that and people knowing your location at all times could be scary. Look, there's a reason that I say oldest daughter, middle daughter, and I try not to use my kid's name because the internet is a scary place. I'm not gonna lie. But this is a selective outrage. I mean, how many times are other people doxxed? How many times are, things leaked out that no one goes to jail, no one gets arrested, but this guy gets arrested? It I just want our justice system to be blind, and right now it seems like the state is getting rid of dissenters.
You can't hide anymore. Your private life is officially over. Over. You leave your house, you're gonna have your picture taken, so you need to get used to the new normal, your new normal. Turtle Riders are gonna take pictures of you, and they're gonna send it to me. You're famous. We need to accelerate it. They, the woman who recorded the video, Chris Albert confrontation, are doing a fantastic job with this. Stated at the 24-minute mark. In episode 604, uh, entitled Colin Albert Drops Out of School, Brian Higgins Flipping, Is the End Near? I said from the beginning, I don't want this to go to trial. That is this defendant's words himself. I don't want this to go to trial, referencing the Karen Reed case. On September 18th, 2023, Kenny posted a blog entitled Canton Cover Up, Part 142. Free Karen Reed. Billboard goes up on Route 1 outside Gillette Stadium in Foxborough. More to follow on his website. The topic of the blog post was about a billboard that read, Free Karen Reed, with a picture of Karen Reed. Kearney praised the organizers of the billboard. In the post, Kearney wrote, thank you to everyone who donated as well. Although millions of people know about the injustice that is happening in Norfolk County, I would bet that over half the population of Norfolk County has never heard of Karen Reed before. That will change because of this three-pronged billboard blitz. It's really time for people in Norfolk County to know about this story because that is where the jury pool will be chosen from. Essentially, Judge, an admission that he's seeking to taint the jury pool in the case. On
Well,
June 3rd,
I mean, providing people with knowledge, you can stretch that. You can say that the prosecutors, press conferences are seeking to taint the jury pool. Why is it the press or why is it prosecutors get to and police get to have press conferences, but defense don't? Why is it every time the defense in Richard Allen's case puts anything out, the state has a big old tantrum? I mean, the double standard here. Look, I don't know. As you all know, I have only gotten, instruction via the trial exploits of my law professor, Darrell Brooks, Esquire, you know, pro per, not pro se. So I don't know the legality of this. I don't know how you can stretch it and, manipulate this to be jury tainting or non-tainting, but it does seem a little, double standardy when the state can have multiple press conferences and, media blitzes, but the defense can't.
June 13th, 2023, Kearney broadcast a live YouTube video, episode 590, which is currently posted on his YouTube page. During the broadcast, Kearney displayed phone records of Jennifer McCabe from the day O'Keefe was killed. The record displayed names to the phone number, displayed names next to the phone number, which appeared to be the user of the other phone. These records had previously been an attachment to an unredacted defense motion filed in Commonwealth versus Reed. During the video broadcast, Kearney cold calls the phone numbers without names associated. In this process, he called the work cell phone of Trooper Proctor. Trooper Proctor stated the phone number that made the call was 413-262-69. I'll omit the last two numbers, Judge. Kearney left the following voicemail. Hi, Trooper Proctor. This is award-winning journalist Aidan Kearney calling. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before doing the investigation, that you were good friends with the Albert family? Why did you, in the report, say that you were introduced to Chris Albert on February 10th when you have known him for more than a decade prior to that? Why did you lie about that, about what time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And I'm just wondering about all those things, and maybe you and I can meet for coffee. Boy, do I have a lot of questions for you. Where were you inside Fairview Drive that night, or that morning rather? Why did you stay there for 4.5 hours? And what did you guys talk about and do? Why are you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot to catching up to do. I talk about you a lot. I feel like I know you pretty well at this point. I know what year you graduated from the academy. I know you were out in West Brookfield for a while. I know some people that you know, so give me a call back when you get this. Now that I have your number and everybody watching also has your phone number, which again is 781 and the remainder of the number.
Okay, that crosses a bit of a line. I personally would not do it. I personally would not give out anyone's phone number. Look, regardless of where I stand, about how I feel about this police officer and whatever shady things he might do, the internet is full of crazy, crazy people, okay? And I wouldn't want it on my head that someone following me or, even loosely associated with the idea of me would do something ridiculous because of something I said or didn't say or didn't even think about, but did it anyways because they saw something on my channel. Again, everyone's line is different. So, but for me, that crosses a bit of a line if I'm judging it correctly. Now, again, legally, I don't know where he stands, but for me, that crosses a bit of a line to, have someone's phone number out on YouTube. Now, again, this is the state's case, so they are going to paint everything in the worst light, and like David always says, at the end of the state's case, you are supposed to believe everyone is super-de-duper all the guilties.
So I'd like to know. She called you again. You called her at 12:49. We're going to get to that. So now I have your number. I'm going to plug you in and we'll talk soon. Essentially, broadcasting the trooper's number to his turtle followers, if you will, seemingly with the intent to have them also harass him. As a result of the cell phone number being broadcasted, Trooper Proctor began to receive random harassing text messages and voicemails. In the 12 hours following Kearney's calls, Trooper Proctor received approximately a dozen text messages, phone calls, and voicemails. The content of the calls and messages pertained to Trooper Proctor's alleged involvement in the conspiracy and called for his termination. Trooper Proctor had to change his work cell phone number to avoid the constant unwanted calls and messages. Michael Proctor is married to Elizabeth Proctor. Beginning in April 2023, Kearney wrote blog posts about Elizabeth Proctor. On May 9th, 2023, Kearney authored a post about Elizabeth. A video was attached to the post. The video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Kearney further writes, I can think of two people who deserve to lose their jobs over this. Alleged conspiracy about Karen Reed, though. Michael Proctor and Elizabeth Proctor. These two lowlifes think they're untouchable. They're nothing but bullies who terrorize people for years, but now they've met their match, meaning the defendant. In the post, Kearney states Elizabeth works as a human resource manager, and I'll omit the place of employment, and posts the main number for the company. The post then says, but you're probably not going to reach anyone that way, so feel free to leave a review on their wide open Facebook page or their Twitter account. On May 10th, 2023, Kearney broadcast a live YouTube video, episode 580, which is currently posted on his YouTube page. During broadcast, at the 1 minute, 6 second mark, Kearney talks about Elizabeth. He states he was going to call her. He repeated his cell phone on the broadcast, a cell phone number on the broadcast, as he was entering the number into a cell phone. Using the speakerphone option on a cell phone, Kearney broadcasted the phone call. The phone call went to voicemail. Elizabeth stated the call came from 413-262-69. I'll omit the last two. Kearney left the following message. Hi, Elizabeth. This is Aiden Kearney calling you back from Turtleboy. We briefly spoke yesterday on the phone. I introduced myself to you, and then you hung up on me. Or maybe that was a bad connection. But I just wanted to see how your day at work went today, if it went well. I noticed that your employer took down their social media pages within 5 minutes of the blog I published about your recent behavior, and I just wanted to see what is it awkward? Were you afraid to go in? Just tell me about your day and why, because
Okay, that's a little sleazy. Look, I don't agree with his tactics. Look, I'm not gonna lie, that's a little sleazy. I I want this case to be fought in the court of law. I don't want this case to be fought by a bunch of ding-dongs on Twitter leaving bad reviews for human resource purposes. That's kind of look, that crosses the line for me, and again, everyone's going to have different standards, but for me, sending your allegedly sending your, group of people to review bomb something, again, allegedly, is is not cool. But again, this is the state saying it happened, and Turtle Boy is alleging that the state is not always trustworthy. And who am I to disagree?
Because that's the part I don't understand, is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun, maybe it's not as fun. Do you like that? That's what I want to know. Do you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? And what's your scumbag husband up to now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Please give me a call back when you get this and we can chat some more. Bye, girl. Following the phone call at the 108 mark, Kenny accessed the social media accounts of the company that Elizabeth worked for and laughed as he stated the pages were taken down and stated the Turtle Boy effect. Oh God. Both Mike and Elizabeth Proctor stated they felt harassed by the acts of Kieran. On Monday, September 25th, 2023, at 6:26 p.m., a Facebook Woods Emerson is the name, posted the following message. Anyone in Canton want to take a couple of pictures for me? DM me, please. At 6:53 p.m., the Facebook post was edited with the phrase, update all set day. On September 25th, 2023, at 8:04 p.m., an X account, formerly Twitter, associated with Kearney, posted this message and photograph. The post depicts the front of 6 Wentworth Road in Canton, home of Michael and Elizabeth Proctor. The white Jeep Wrangler in the photo belongs to Jennifer McCabe. And there are photographs that are appended to this report I'm reading from, Judge. The following day, Kearney broadcast a YouTube video episode 617. At the 19-minute mark, Kearney stated that he ran the plates of the vehicle depicted in the photograph. Kearney showed photographs of 3 vehicles parked at the address. He showed photographs of each vehicle and stated the registered owners of the vehicles by name, Michael Proctor and Elizabeth Proctor. The term ran in regard to a motor vehicle registration is commonly used in law enforcement. The term means the information was queried through law enforcement database for the purpose of obtaining information. Kearney 61. Jen McCabe was seen at the Proctor's house at 6 p.m. tonight, despite allegedly not knowing them personally. I would parenthetically state, Judge, that it was later determined through an investigation by state police that a dispatcher in the local police department made contact with Kerry and unlawfully and illegally accessed the registry of motor vehicles database to provide him with information he was not entitled to. Information maintained by the registry of motor vehicles is accessible to law enforcement through the Criminal Justice Information Service. Authorized individuals have personalized access to the CJIS logins and accounts. Recertification standards, which include lessons and tests, continuously assert that CJIS users are trained to the standards and do not disseminate protected private information unless for a legitimate law enforcement purpose, as described in Massachusetts Code of Regulations 803 CMR 7.09. On Tuesday, September 26th.
You know, I hesitate to say this, but I'm sure other journalists have back look, I'm not defending everything he did, but I'm sure other journalists have sources, you know, sources at this time, unnamed sources. How many stories have we heard with unnamed sources at this time? It just seems very convenient that this particular journalist is being demoted to a blogger and, you know, stripped of his sort of journal or freedom of the press sort of protections and, the things that normal journalists would do semi-ethically. I mean, let's be honest, a lot of this stuff gives me the I'm choosing my words. A lot of this stuff I would not do, but I don't have the personality type to be an investigative journalist. I'm not confrontational. I don't, you know, want to get in people's faces. I don't like confrontation. So, it would take a certain different kind of personality type that maybe is a bit more audacious, a bit more willing to skirt the rules. So, I it's not my bag, babe. It's just not my bag.
2023. Lieutenant John Fanning of the Massachusetts State Police conducted a CJIS audit to determine if any CJIS user queried the following: Massachusetts registrations. I will omit the registrations at this point, Judge, but one is for Matthew McCabe's vehicle, who is Jennifer McCabe's husband. Another is for Michael Proctor's vehicle. Another one for Elizabeth Proctor's vehicle.
Also, I mean, how difficult would this be to find on the internet? Again, I know people are much better at me at interneting, but could this all be found on the internet?
The audit produced results indicating that all three vehicles were queried by, I'll leave the individual's name out, a dispatcher in the police department saved JIS account at 6:22:19 p.m.
Okay, I retract my first
5:03
statement.
p.m. and
My
7:10:44
my
p.m.
seconds ago
This
statement.
individual is employed as a civilian dispatcher. On Wednesday, September 22nd, 2023, Lieutenant Fanning and Sergeant Yuri Buchanan interviewed Webb at the Avon Police Department. Uh, Individual stated should be employed for a period of 3 years, and goes on to indicate that the query was made at the defendant's request. I'll skip some of this, Judge. The dispatcher provided her cell phone to investigators. Investigators observed communication between the dispatcher and Clarence Wood Emerson, the pseudonym used by the defendant, on Facebook Messenger on the cell phone on September 25th at 6:18 p.m. Dispatcher sends the message, "What you got? I'm here till 8 a.m." Clarence responds, "Sorry, H500," which was a registration. After several messages back and forth, the dispatcher sends the message, "Matt McCabe," to which Clarence responds, "Got him. It's parked at Michael Proctor's house as we speak. Thanks, this is huge." Dispatcher responds with a message again, "Please keep me private. I don't anticipate fucking up in life and never want the wrath of you." At 7 p.m., Clarence sends the message, "Of course. Any chance you could run two more?" Dispatcher, "Sure." Clarence sends pictures of two vehicles parked in the driveway, Wentworth Road. The dispatcher said Clarence 80 blank numbers Proctor. Clarence then asked about another registration. "Is that Lizzie?" To which the dispatcher replied, "Yes, Lizzie, Elizabeth Proctor." Dispatcher said she has read Turtle Boy blog posts in the past and has followed his media regarding Karen Reed closely. A check of Webb's Facebook page information publicly available believes she is friends with Clarence Woods Emerson. Dispatcher has posted numerous posts and comments on content on Facebook supporting Karen Reed's innocence and copying Kearney's claim of police cover-up. On a YouTube video posted on October 2nd, 2023, Kearney acknowledged it is illegal to obtain information about the registered owner of a motor vehicle and discussed why it should be legal. I interviewed Jennifer McCabe regarding the incident. She stated she had never met Elizabeth Proctor or Michael Proctor prior to September 2023. Since the first meeting several weeks ago, Jennifer and Elizabeth have communicated regarding the constant harassment, intimidation, and public attacks. Jennifer stated they bonded over sharing the ongoing experience. She traveled to Elizabeth's home to discuss the harassment they had both been subjected to. Based upon the foregoing facts, it's probable that Aiden Kearney committed the violation of Massachusetts general laws, which is section 13B, witness interference, intimidation of a witness.
So
Michael Proctor,
I'm
Elizabeth
guessing
Proctor,
that's his
and the statute,
lawyer.
whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, conveys a gift, offer, or promise of anything of value, or misleads, intimidates, or harasses another person who is a witness or potential witness, person who is or was aware of information, records, documents, or objects that relate to a violation of the criminal law or a violation of conditions of probation, parole, bail, or other court order, a judge, juror, grand juror, attorney, victim witness advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer, or D, a person who is or was attending, or a person who has made known an intention to attend the proceeding described in the section, or a family member of the person described in the section, with the intent to, or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding.
So I guess my bigger question in all of this, and let me see how much farther it goes, but my big question is is this going to be enough to interfere in Karen's case? Witness intimidation, I know, is a big deal. It's we in our criminal justice, we don't want people scared to testify and things like that. Could this be
A dangerous hearing, a motion hearing, a trial, or other criminal proceeding of any type, or parole hearing, parole violation proceeding, or probation violation proceeding, or administrative hearing, or probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk hearing, court order, mediation, or any other civil proceeding.
Sorry, I have
Punish, harm, or otherwise
I have
violate
someone to
any
pick up,
of the
so I'm
laws
trying to get
or
this
causes of
done.
action for such person or such person's family members' participation in any of the proceedings described in this section. And it goes on to state the penalties for that offense. Based upon the foregoing facts, the Commonwealth believes it will establish a trial that Hayden Kearney committed a violation of Massachusetts General Laws, Chapter 274, Section 7, conspiracy to commit intimidation of a witness by entering into an agreement with the dispatcher named earlier to obtain sensitive information to be used in blog posts and videos intended to harass, intimidate, and cause emotional harm. And given the continuing harassment of witnesses for the murder of John O'Keefe, we believe that the defendant will be found guilty at time of trial should this matter go to trial.
Okay.
That, Judge, that recitation deals initially with Elizabeth Proctor, the wife of Trooper Proctor. Now, there are an additional 8 complaints that I have here, Judge. Much of the verbiage is recited, is also recited in these complaints, as they obviously have to independently stand on their own. However, for purposes of this arraignment, I can skip forward, Judge, and go to just the pertinent sections for the individual victims / witnesses, because they are both in this matter. But Juliana Nagel, on Saturday, July 22nd, at approximately 1200 hours, Kearney departed Shaw's 134 Nathan Street in Norwood, accompanied by a number of motor vehicles, for something publicized as a rolling road rally. Kearney began a YouTube live video. The YouTube Live allows users to broadcast live videos on the YouTube platform, which can be later saved and distributed on a user's account. At the beginning of the video, Kearney was operating the motor vehicle.
I love how they have to explain what YouTube Live is or what streaming is. I know they have to do it for purposes of the court and everything, but I love how they have to do it. It just, it's like, and this is a cellular phone, and you can use it to text people or use it shockingly as a phone.
Motor vehicle and stated at least 100, 200 people are in the caravan of vehicles. He further stated that he did not broadcast the locations of the protests prior to the departure of the rolling rally. During the video, he stated, this defendant stated, the purpose of the rally is to protest the murder, cover-up, and framing of an innocent woman. He stated some witnesses will be in jail within a year and brags about being to locate witnesses wherever they travel. During the duration of the rally, he thanked other members of for attending the rally. Juliana Nagel, 25 years old, lives, I'll mirror address, in Canton with her 2 parents and 2 siblings. Juliana was home with her mother at the time of the protest. Juliana and her brother were present at 34 Fairview Road and had been interviewed by investigators. When Kearney arrived at 79 Highland Street, he identified the residence as her home. Kearney made a statement to get the attention of her neighbors. He described how O'Keefe was beaten to death at a house where Juliana was present. He stated, at any point, Julie Nagel, you can come out at any point. Nothing is stopping you from telling the truth. You know what happened that night. He continued to state, you can't get away with it anymore. Too many people know you're going down with them. Nothing is stopping you from coming.
I mean, again, it's not my cup of tea. This is not something I would do. I don't know the legalities of it. I'm just bringing you what the state is alleging. Hopefully, we'll get through this video. I should have done a live stream, but I really didn't anticipate it being this long, and the day has just been a day.
Coming forward and telling the police what happened. Kearney claims Nagel lied to investigators about her observations the night O'Keefe was killed and is complicit in the cover-up of a murder. Kearney stated, you might as well tell the truth and let the world know what happened. Neighbors, maybe you guys could help us pressure them into this. Julie Nagel was involved with, was at the murder of a Boston police officer. She knows what happened. She is actively involved in the cover-up. She should not be able to walk around town like none of this happened, while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. The truth will set you free. Kearney is in front of the residents for approximately 10 minutes. At the conclusion of the speech, he stated the next location is the home of Canton Police Department Deputy Chief Thomas Kelleher. While traveling,
And those are some boobs with Boston on it. Guess we know what the cameraman man was looking at.
About as far as you can go to intimidating a witness, as to what his intent was. During a recorded interview on the YouTube account Wristflex, dated August 20, 2023, the defendant made comments about his influence on the jury pool. I want the world to know what happened here. They want the story to be silent, nobody knows about it. They want to be able to find a jury pool that has never heard any of this shit before they can manipulate them the way they manipulated everyone else, and I'm not allowing it. Not allowing them to do that. Happy to do it. Elite mass corruption, sure boy, I want 4 more. Based on the foregoing facts I read, Judge, it's clear that the defendant committed a violation of Chapter 268, Section 13B, which is intimidation of a witness and witness interference with Juliana Nagel. I will not recite the paragraph that I recited earlier as to what the language of the statute is. And for this reason, Judge, on the second complaint, docket 1151, we're going to be requesting those same conditions of release. Does it have about perhaps another hour going, or want to take a break, or keep going, whichever your honor indicates?
Let me ask you this, the issue with bail and release conditions.
Yes, Your Honor.
So, haven't you covered that?
Well, there-
Why should we put a bail on in certain release conditions?
There are, Judge. There are other witnesses, so I would ask that those conditions apply to each of the docket numbers. The facts are fairly similar, but as there are different witness/victims in these cases, the specific facts vary. But they're generally the same content as
I understand
the
it's
12.
an issue, which means that the court magistrate on probable cause to issue complaints. So that's been established.
Correct.
And, I mean, if the alleged victims in the various cases were to be named, then we would, to the extent that I allow any or all of your proposed conditions, it would encompass those people, wouldn't it?
It would, Judge.
Yeah.
So I would ask Your Honor to adopt the Commonwealth's recommendation as to the conditions.
Attorney Reynolds, if you go to the microphone, then perhaps Attorney Novak just slide over and tell me, what is your position with regard to the Commonwealth's request for cash bail in the amount of $1,000 and the various conditions?
Yes, Your Honor. As far as the bail, we're asking for release on person. He has no record. He lives with his family in Holden, and he has 2 children that he supports. And what we're providing here is that we don't believe that because of his record or because of his commitments that he would be in danger of flight or creating a problem in terms of needing bail. As far as the conditions go, my client states that he is a news person who is using his First Amendment rights to cover a story. Now, I know that he is doing it through YouTube, the social network, but there are a lot of people who do this. And he is requesting that he still be able to do this news coverage. He vehemently denies that he's intimidating or harassing it, that the trooper involved is a public figure, that there is a potential selectman involved, that he goes to meetings, and he feels as if that he should be allowed under his First Amendment right to pursue his story. Now, as we go through it in terms of the threats, I just would like to point out that when I read the statements that the prosecutor stated, I see opinion. I don't see threats under the way my client is acting. I said from the beginning, I don't want to go to trial. Most people don't want to go to trial. That's an opinion. That's not a proceeding, so he didn't want to kind of read cases to go to trial. But still, it's an opinion, and he put it out on the web. It's really important for people in Norfolk to know about this story because the jury put it. Again, opinion. Again, the internet allows for that. I'm sure that, or I would hope, that if any of these statements would have violated YouTube policy, they could have contacted that and had taken that.
Well, that is an interesting point. If it didn't violate YouTube policy, they didn't take it down. He is arguing an opinion piece. I mean, I don't know how that's going to work. Again, I think that this is something that maybe I'll show to David and he can go through and maybe we can look at this again with lawyer eyes because there are things that I'm greatly ignorant about as far as the law.
I would provide that this is a lot of reports, and for some of these conditions to apply, such as controlling his followers, not sure how we would do that. I would believe that if he were allowed to continue to pursue the story with his bail warrants, that the police could access or take a look at further events that he does. Meaning that if he calls for one of these local rallies, someone will give a call, they can go out and they can determine whether or not it's intimidating or if there's a charge of a crime. I mean, that's what I'm arguing to allow the First Amendment to go forward. You can to allow the prosecution to continue to monitor the situation. They have police involved, and then each event that comes out of it is under bail warrants. If he does something wrong, he's not here. And that would be my argument.
Thank you. Attorney Miller, if you would, for the court and police department, would you identify the alleged victims in the various complaints by name? I think I have them all, but I want to make sure.
I will, Your Honor. In the first instance, it is Juliana Albert. In the second instance, Judge, it is Christopher Albert. And these are in addition to the ones I've already identified, Judge. In the next instance, Judge, it is Michael Proctor. Then we have Colin Albert. The intimidation of a witness with a co-conspirator there were 2 victims in that matter, Judge. Jennifer McCabe and Elizabeth Proctor. Those were instances where the vehicle registration was run. We have Jennifer McCabe. We have Matthew McCabe, and that is the remainder of the complaint so far, Judge.
That is a list, if you will, of the alleged victims in the case as to which you're seeking specific conditions.
Yes, Your Honor.
Thank you. All right, it might be given that individuals lack a criminal record. I don't, this is not a cash bail case. I'm releasing them on personal recognizance. Also, I don't see it as a GPS case. I'm not opposed to GPS. What I am doing is opposing the following conditions. Stay away, no contact from each of the named witnesses that were just listed by Attorney Mello and captured by the court and the probation department. Stay away, no contact. That means direct or indirect, including but not limited to mail, email, text, telephone, social media, or via any other mechanism, if you will, direct or indirect from all of the named alleged victims. Mr. Reynolds, I'm sure you'll advise your client that is broad, and that is broad from my view on purpose. And if it comes before me or any judge, and a judge would find that he violated a release condition, he is subject to incarceration for up to 90 days without bail.
Thank you, Your Honor.
I need a date.
Well,
Have you coordinated that? Mr. Mello, what's the comment? It's a little far out.
He'll find his fine.
It's fine, okay.
Okay, so it looks like he has been released on his own recognizance, and he does not have to wear a GPS ankle monitor, but the judge is telling him to stay the heck away from all of the witnesses, and that means don't talk to them, don't call them, don't tell people to call them, don't look at them. Like, basically, FAFO. If you F around, you will find out, sir. So that is the update in the Turtle Boy. I am going to try to, not X him, that doesn't sound right. I'm gonna try to direct message him and see if I can get an interview. I know he's probably going to be bombarded, and I am a super duper duper, duperty duper small channel, but you miss 100% of the shots you don't take. So, we'll see. But I did wanna get this out there for you guys. Reindeer did send this to me, so thank you so much for Reindeer, and thank you guys so much for watching. I know this is a longer video of mine, so thank you so much. Have a wonderful rest of your Wednesday.